Hi, Jasmine here from Redwood Financial, and this week's frequently asked question is what happens if I do not register my lasting power of attorney? It's a really good question and it's a real big bugbear of mine, so I'm really pleased that I'm answering it this week. More often than not, when I meet a client who already has a lasting power of attorney set up and had created, whether that's been done by a will writer or a solicitor or estate planner, most of the time I find that the lasting powers of attorney have been done but have not been registered at the Office of the Public Guardian. And that is a major frustration and red flag for me. What's the big deal, Jasmine? Why do we need to register the lasting powers of attorney right away at the Office of the Public Guardian if we haven't lost mental capacity yet? Very good question. Well, there's two big issues that I have with people who don't register their lasting powers of attorney in advance of losing mental capacity. The first one is, how do you know the lasting power of attorney has been done correctly? Whether you did the lasting power of attorney yourself or you paid a professional to do it, the truth is we are all human, and these legal documents are created by humans, and therefore there is the potential for there to be human error, whether that's in the witnessing and the signing of the legal documents or the physical drafting themselves. Until such time as you send the lasting powers of attorney off to the Office of the Public Guardian for them to register, you don't know if they've been done correctly and valid, and they haven't been approved by the Office of the Public Guardian. If we wait until you lose mental capacity before these legal documents go off to be registered, and then it turns out there was a mistake and an error in producing them, it's now too late to fix the problem, and you've now been left without mental capacity, unable to create a new lasting power of attorney document. So actually, the one thing that we were trying to avoid by doing the lasting power of attorney in the first place has now been exactly the same position as if we hadn't have done the lasting power of attorney. So it's so important to make sure that these legal documents are correct, and the only way to possibly know that for sure is to have them registered with the Office of the Public Guardian before you lose mental capacity. So that's issue number one. How do we know there's a mistake? How do we know they've been done properly? Issue number two is about time. Since its inception, the Office of the Public Guardian has a ridiculously long waiting time to process the registration of lasting powers of attorney and even the old style enduring powers of attorney. When lasting powers of attorney were first introduced in 2007, the average time to register a lasting power of attorney was between 10 to 14 weeks. During the COVID pandemic, and here we are nearly 2 years later, we're still seeing wait times at the Office of the Public Guardian now being extended to anything like 16 to 26 weeks for registration to take place. So now let's just run this scenario through. You've lost mental capacity. Your loved ones are now looking to use your lasting powers of attorney in order to be able to make important and critical decisions about your finances and your health and welfare. Your family want to be able to make these decisions quickly and legally as soon as possible, but you haven't registered your lasting power of attorney in advance. What does that mean? Your family now have to get the lasting power of attorney sent off and registered, and they're now going to be faced with anything between 16 to 26 weeks of waiting before they can do anything, before they can make decisions about your health, about your finances, and start taking care of things for you. For most people, that would be an unacceptable amount of time to wait, and it could be really serious if we're in a position where decisions about health are being made that we don't agree with or that we would want to make a different decision. So in order to make sure that your loved ones are able to step in and start making decisions for you and take care of you in those eventualities, we need to make sure that our lasting powers of attorney are registered in advance. Let's go through that waiting period now while you're fit and healthy. And once the legal documents are all registered, we know that they're legally valid, but they're also now ready to use immediately the moment you lose mental capacity. So there is no delay to the family stepping in and starting to help make decisions on your behalf. So those are the two big reasons and why I have such a bugbear about it when I come across people who have done the lasting powers of attorney but not been advised whether or not they should register them in advance. Registering does cost money, and perhaps that's what puts people off, but at just £82 per lasting power of attorney, the cost is really insignificant compared to the implications if these legal documents aren't correct, or we have to wait nearly 26 weeks to have them registered and ready to use. So if you do have lasting powers of attorney that aren't registered, please, I hope you watch this and you get them registered as soon as possible. For those of you that are clients of ours at Redwood, it's nice and simple. You have nothing to worry about. At Redwood, we insist on registration in advance for those two reasons that I've taken you through. So if you've done your lasting powers of attorney with us, rest assured, they've all been registered and rubber stamped by the Office of the Public Guardian, and they are ready to use the moment your loved ones need to use it. For more information about lasting powers of attorney, you can check out our website and read more articles on this. We've also got our free wills, trust and estate planning webinar that also contains lots more information about things like lasting powers of attorney and why they're so important. And if you have got any other questions at all, please just get in touch and you can have a complimentary telephone meeting with myself or Steve, our other estate planner in the practice, and we'll happily answer those questions for you. So hopefully that helps answer this week's frequently asked question, and I look forward to receiving more of your questions and answering more of them next week.